So we are going to be talking about the life cycle of a textbook, psychological and legal perspectives. And as I tell you a little bit about my own background, you'll see how psychological and legal perspectives kind of fit together. When I was in graduate school at the University of Michigan, in the late 1960s, there was a popular psychology professor named Elton McNeill. He was an engaging teacher, a good writer. He was a little bit ahead of his time in figuring out that the new emphasis of the 60s on personal growth and social consciousness would find its way into introductory psychology textbooks, and that there would be a large market for textbooks that could successfully integrate these sorts of approaches. One name for this approach was humanistic psychology. Psychology that went beyond the traditional experimental psychology and the traditional Freudian psychology to focus on people's lives, values, larger social issues. Now, if you wanted to have your text adopted in introductory courses, you'd have to approach this very carefully. You wouldn't want to call your textbook humanistic psychology because you would be written off as a bleeding heart. You had to be more careful than that. Adoptions for large introductory courses were made by committees. A few of the committee members might be open to so-called humanistic approaches and social applications, but the others would not be. So you'd have to sneak this kind of thing past them. If you were successful at this sneak play, you might have a large market. And while you were at it, and maybe as important, you might have some real impact on the way introductory psychology was taught. I don't know, how many of you have ever taken introductory psychology? Oh, good. Okay, so you have some idea of how it was taught at different stages depending upon when you took it. So back in the late 60s, early 70s, what Elton McNeill did was close to brilliant. He did not entitle his book Humanistic Psychology, but he did not call it psychology or introduction to psychology either. He called it the psychology of being human. The basic outline of the textbook was like the outlines of most established textbooks, with chapters on the brain and the nervous system and learning and memory and perception and things like that. But there were also chapters that you would not see in other books at that time, including chapters on consciousness, violence, sex, prejudice, man and culture. And there were also separate sections that were printed on purple paper to make them look different on the applications of psychology to such phenomena as poverty, suicide, pornography, even psychoecology, things that you would not have found in other introductory textbooks at that time. Professors could assign these chapters and these sections, or they could skip them. The professors with more humanistic or social activist sorts of orientations, often the younger professors, not always, would assign them. The more traditional professors, whether experimentalists or Freudians, would look the other way and skip them. And this was all before we had custom editions and electronic versions that could be sliced and diced every way. This was a more primitive, let's say, way of slicing and dicing and trying to give audiences a choice. The book was published by Canfield Press, which was a, call it, more mellow division of Harper and Row, based in San Francisco. And the book did very well. It didn't overtake the very best sellers in the field, but it secured a respectable piece of the pie. And it did so despite one of the deadliest covers that I can imagine. That was the first edition of The Psychology of Being Human by Elton D. McNeill, published in April of 1974. Late in 1974, as a 30-year-old assistant professor, I received an unexpected phone call from the psychology editor of Canfield Press, a soft-spoken man named John Miller. Elton McNeil had died of a heart attack on March 27, 1974, at age 50, a week before his book was published. By the fall, Canfield could see that the book had found an audience and had started a search for someone to prepare a second edition. And John had done some scouting at the University of Michigan, and I was recommended as one person who might be able to fill that role. So they flew me out to San Francisco. I met with John and others at Canfield, and although this was not something that I had expected to be doing at this point in my career, I spent much of the next 10 years preparing the second edition of The Psychology of Being Human, which was published in 1977, and then the third edition, which was published in 1981, and then the fourth edition, which was published in 1985. You see some slight changes in the title, but the same book evolving. This was a trial by fire for me in textbook writing, and also a challenging exercise in contract negotiation, which was complicated by the fact that the situation involved not only me and Canfield, but also Marjorie McNeil, who was Elton McNeil's widow. But I managed to deal with this successfully with some good legal help. And for some reason, I found the contractual side of things not only challenging, but also quite interesting, fascinating. And that was one of the reasons, not the only one, but one of the reasons that by the time I was working on that fourth edition, I was also applying to law school. And by the following fall, when I was taking contract law, all first-year law students take contract law, I did have a head start because unlike many of my classmates, I had actually participated in negotiating a few contracts. And so starting in my 30s and extending into my 40s, my life, just like many of your lives, became measured not by years, but by editions. My first son was born, I don't know what year, but when the second edition was published. And my second son was born, who knows what year, but when the third edition was published. And by the time the fourth edition was published, I was in a midlife passage and thinking about switching careers. So now I've started a search of my own. If I was going to start at square one in a new career, which I eventually did, I wanted to keep the book alive. And it ultimately came out in a fifth edition by me and my two co-authors. At this point, the pendulum was switching back to the basics. There are always backs and forths of the pendulum, as you know. Becoming human was becoming a little more dangerous, and so we decided to call it psychology. But it kept a brilliant name, psychology, but it kept a socially conscious orientation. Unfortunately, the fifth edition didn't do as well as the second or the third or the fourth. Textbooks do have their life cycles, and they don't always last forever. And it's not always easy to pinpoint the causes of death of a textbook, and there may often be multiple causes involving authors and publishers and markets. In this case, there was at least one obvious factor that you've probably already thought of, which was that the book had been on a 4-year revision cycle, and here you have a mysterious 8-year gap. The book had gone into hibernation when I went into law school, and it did not reemerge until 5 years after I had graduated. And there was as much competition or more than ever in the field, and very few of our doctors stuck with the fourth edition for all those years. And as many of you know, the trick here is to gain adoptions, but also to keep them. And once you've lost adoptions for any reasons, it's very hard to get them back. But I did have my consolations. First of all, although I didn't fully appreciate it at the time, I learned the hard lesson that some of you have learned and others of you haven't. That not all adventures in launching and nurturing textbooks go well, and there are many reasons why they don't. As Brenda will be talking about later, an appreciation of the risks of textbook publishing is useful even at the very start of the enterprise, involving both contracts with publishers and arrangements with co-authors. And then a second consolation for me was that by this time my day job was at a law firm with a strong publishing practice, and I had begun to work with clients on their textbook contracts. More recently, I formed my own practice, which is now Rubin and Ulrich, where one of our specialties is working with textbook authors. Both my own experiences and our experiences with clients have taught us more about the life cycle of textbooks. As Brenda will say more about shortly, our clients include authors at all stages of the life cycle of textbooks. The earliest stage of launching a new textbook, from a gleam in your eye to a proposal to a contract with a publisher, an early stage of preparing and publishing the first edition, a middle stage of textbooks that have gone through one or more editions and are now trying to maintain and increase their relevance and impact and market share, and sometimes expanding the franchise to other related sorts of works. And then a late stage, phasing out textbooks that have been around for a number of editions and are trying to prosper or just stay alive, often at the same time that authors are trying to retire or to scale down their textbook work. This is an idealized set of stages. In real life, it's not always so neat. Sometimes you may find yourself in a hybrid stage or in several stages at once, but it does provide a way to focus on certain prototypical tasks that face textbook authors, and as we'll see shortly, also relate to the legal issues and challenges that face textbook authors. In the launching stage, the tasks include finding your own distinctive approach to the subject matter, deciding whether to go solo or to assemble a team, finding a publisher who you would like to work with and who would also like to work with you. Many of our clients are dealing with these tasks, often focusing on finding the right publisher and negotiating a publishing contract with that publisher. As Brenda will expand on, although you are in the launching stage and you're filled with youthful enthusiasm, and that could be at any age, the negotiation of a publishing contract often also provides an important nudge to consider the things that might happen in later stages. Because your initial contract will set, not necessarily immutably, but it will set various terms that will become very important, not today, but decades from today. In the early stage of preparing and publishing a first edition, the tasks include research and writing, a lot of research and writing, often a whole lot more research and writing than you ever imagined, and working with your publisher on a whole multitude of issues involving the content and publication and marketing of your book. The legal issues can include working together with the publisher to accommodate all sorts of unforeseen events. The author discovers, this is not uncommon, that it's going to take longer than she thought, maybe much longer. The publisher discovers that the market is changing in some unexpected ways, or that it is launching some new interactive learning packages that no one thought about, or thought about who would deal with when the book was first contracted. Sometimes the contract has to be interpreted or changed to take account of these developments. In the middle stage, preparing later editions, The tasks include continual assessment of the field. To what extent does the initial spark for the textbook still guide the project? To what extent must the authors seek new sparks to take the work into the future? A central issue here that is also central in the life cycles of people is the constant tension between continuity and change. We want our books to have continuity of approach and tone. We want our adopters to know that Schwartz's Economics, 5th edition, will continue in the tradition of Schwartz's Economics, 4th edition. That if you like Schwartz in the past, you're going to like Schwartz in the future. And that it can be taught in the same ways without requiring professors to come up with some new way of approaching the field. But on the other hand, a book that changes too little becomes stagnant. We want to revise our books not only for marketing reasons, such as combating used books, but also in order to reflect changes in the field, to shape changes that you think should be made, to remain fresh and stimulating to your adopters and to your students and to yourself. In the 2nd and 3rd and 4th editions of the Psychology of Being Human, later Psychology Being Human, later Psychology, I think I managed this pretty well. I think that one of the things that might have gone wrong with the 5th edition, in addition to that 8-year gap, was too little continuity, too much change. Among other things, it had a lot of new bells and whistles, and maybe they had a few too many bells and whistles. And if you remember the 5th edition, it doesn't look quite like Rubin and McNeill anymore. In fact, you won't see McNeill's name. You'll see 2 other names of very good co-authors, but perhaps we lost some important continuity at the time. The 2 new authors were quite distinguished, I might say. Letitia Ann Peplau is a terrific professor of psychology at UCLA, and Peter Salovey, who was then a young assistant professor at Yale, who had been recommended to me, is now the president of Yale University. So I did get him off to a good start, but the book itself never went so far, and maybe it should have been more continuous. Maybe McNeill should have been more obvious, even that many years after his demise. Finally, we get to the phasing out stage, and one of the tasks includes decisions of founding authors to retire or to reduce their involvement in the textbook in order to pursue other interests, and so that one important task can be to find the right collaborators or successor authors. Some people are in the very fortunate position, I know a number of you are, of having a junior colleague who they've already worked with successfully and have, at least to some extent, tested, who they think they have good reason to think could handle the job and come in and collaborate and eventually take over a book. Other people are not so fortunate, and they need to start from scratch in finding such a collaborator or successor. The one piece of advice that I can give you about this, based on my own experience and also the experience of a number of our clients, is that collaboration is not easy. Collaborators often have different styles and orientations, and their differences are not always obvious at the outset. In some ways, the opportunity that I had to collaborate with a deceased author was a tremendous gift, because it can be a whole lot easier to work with a person who can't argue with you or overrule you than with someone who can. Well, what I lost, of course, was a senior partner who could guide me and mentor me, which would also have been quite valuable. A final task that sometimes comes up in the phasing out stage is that of retrieving one's rights in the book, if for any reason it can no longer be successfully published and marketed by the original publisher. Especially nowadays, when electronic versions of books can be easily produced and marketed, it can be very important for the author to get back those rights from the publisher so that he or she can make new arrangements for the book and resurrect the book. And in particular, some of the companies who are represented here, including Flat World, which is Sean's company, and other companies, are quite interested in bringing, call it, old books back to life, because they often have more value than one would think. But the issue of getting back those rights can be an important one. A final theme, and how am I doing in time? Already? Well, then I think I should skip the final theme. But the final theme is very interesting, so you can ask me about that later, and we'll have time for questions later. And they have to do with, again, the life cycle of the textbook being in some ways like the life cycle of a person. How many of you have heard of Erik Erikson and the opposition between, as part of his stages of development, autonomy and control? Well, that runs very much through textbooks. It's very important, so you can ask me about that later. Because the best textbooks, the best contracts do take into account authors' needs for autonomy, while at the same time respecting publishers' needs for a degree of predictability and control. And that's why some of the best contracts include provisions for approval and consultation that may not appear in the publisher's boilerplate, but reflect on the needs of the authors and the publishers as they progress through the lifespan. So at this point, Brenda will take over to discuss legal aspects of the life cycle of textbooks. Now, is this? Do you need this? Okay.
All right, how's that? Can you hear me? Okay, great. Because I have to advance slides and look at my notes, and I only have so many hands. So I'm going to. So I think Zick has set us up really nicely in thinking about these 4 phases because they really map well onto the legal issues that arise as you are working through them. And you'll see here, I'm kind of going to frame my part of this in the same 4 phases, but we're going to dig deeper into some of the legal issues and the kinds of legal materials you'll be dealing with at each of them. And we did hand out our PowerPoints with places to take notes, so you don't have to copy all this down. I'm going to go the theatrical route of just dropping papers as I go. So let's talk about pre-publication. Even before you are at the point of dealing with any kind of contracts, there's some things to think about from a legal perspective. First, consider your sources. So if you are writing your first textbook, it's likely not coming out of thin air. You are building it based on your expertise in this area, and that may already be captured in, say, your course materials or in other books you've written. And you need to think about, if you're planning to incorporate these into your book, do you actually own them? And the assumption is often that we own what we write, which is a very intuitive one. But in fact, you are guided by other contracts you've signed, as well as, say, if your institution's intellectual property or copyright policy is such that what you create in your job belongs to your employer, then you don't actually own what you've created, and you'll need permission, as anyone else would, to use your own materials. So keep these things in mind, and then also consider, if you're integrating someone else's materials, whether it's a collaborator of yours or just somebody who you think is a good source of content or ideas, that you're going to have to deal with permissions for these materials at some point in time. So the earlier you can start to think about those issues and reach out to those people, the better position you'll be in the long term. And a quick heads up that I think is very helpful. If you have already written, if you're not in that just putting together a proposal that you're going to shop to a publisher, but if you've already written a lot of the book and are now going to start shopping it around, it can be a very good idea to register copyright in that before you start distributing this in a wider way. It's simple, easy, and inexpensive to register a copyright, and it just marks in time what you created at that time. So if there's ever questions of if somebody copied or infringed your work, you can show, no, I registered this 5 years ago. This is what's on record with the Copyright Office. Clearly, it's mine. So the other thought is on, are you working alone or with a collaborator? And as we're gonna keep circling back to this collaboration question because it really comes up at every stage of the way. But And we could do a whole separate session on collaboration agreements, and maybe next year. But briefly, I want to just talk about a few key things. First of all, should you have a collaboration agreement? Yes. I think the more, and it's as much the final document as the process of making it with your co-authors to talk through how this is going to work, and then try to put that on paper. Because if you have to write down and send to your collaborator just even a work plan that says that you're doing these chapters, I'm doing these, you're in charge of this, I'm in charge of that, is that what we all are understanding? This can help alleviate a lot of problems down the road. So I like to think of it as a prenup. It's what we put together when we're all getting along, and hopefully we'll never have to look at it, but if we do get a divorce, it will come in handy. So very quickly, when we can delve into these, and I'm happy to talk later, the major things that a collaboration agreement should cover is obviously who does what, how you're sharing the workload, who gets what, how are you going to divide what you earn on this, and also thinking about expenses. If there are expenses involved in making the book, how are those going to be shared or reimbursed? How are disputes resolved? This can be very tricky, and there's often questions of whether you have a senior or junior author. If your co-author's dead, that's an easier one. But in some cases, you agree that you'll work in good faith to work it out. Maybe you'll let the publisher resolve the dispute. Maybe you will find a neutral third party. But it's good to think ahead of time if disputes arise. How are you going to address those? And then again, those long-term issues, how to end the relationship. What if one author wants out? Well, then who picks the replacement? How is that person chosen? Does the departing author get royalties? For how long? What if somebody's deceased or incapacitated? Do you want the heirs of that person making these decisions, or would you rather the two of you think through these issues ahead of time? So, an ounce of prevention can really alleviate a lot of problems and heartache down the road. But okay, let's get to the meat of it. I'm making quite a pattern here. Okay. Preparing and publishing the first edition. And to quote my favorite musical, do not throw away your shot, because, no Hamilton fans out there, okay. Because in your early negotiations, in the contract stage, this is when you have the most leverage to improve your publishing contract. Because at this point, if you're at the point of finalizing a contract, your editor has already advocated for you internally. They've already created a lot of momentum. They've invested a lot of time and internal capital to bring your book to this point. So they have a real incentive to bring this to a full contract, as do you. And so this is the time to get a lot of boilerplate terms improved. And so why it's so important right now to focus on not just the short term and what is my royalty rate going to be when this book comes out, but thinking ahead to all these later stages that Zick has been talking about as well. But as far as, so that's what I'm saying, think about phases 3 and 4 while negotiating your contract in phase 2. But the major things you want to think about at this point are your royalty rates. And obviously your publisher is going to propose something. And it's a good idea to do a lot of talking with colleagues, and here's a great place to do that, to see what are the royalty rates, the current royalty rates. Also thinking about escalations. So this is sometimes, if sales hit a certain point, your royalty rate will get bumped up. And we want to think about those, again, now. And that's the kind of thing where, because a publisher doesn't have to put that money on the table up front, you might be able to get more, push on that. Because unlike in advance, where they have to shell it out right now, but escalations are deferred payment that they'll have to make, so you can have a little more leverage on that. You also want to think about other parts of the contract, like competing works. There is often restrictive language about you not being able to publish a competing work. Well, the language in that section can be stretched and narrowed. So you want to make sure you, as an expert in your field, are not constraining yourself with this kind of competitive clause. There's some, the out-of-print definitions, which Zick alluded to, and we're going to talk more as we get into the later phases. But, all these things come up now, and you also want to be thinking, things like advances usually happen just on the first edition. Sometimes you can get a grant for the second. But there are other ways to be thinking ahead to improving your future editions. So, for example, you might have a low royalty rate, base rate for your first contract, but we've been able in some cases to negotiate that if sales hit a certain point on that first edition, then the second one will start at a higher rate. So there's ways to play with these for your long game to be better. So always be thinking ahead on those. And that's moving ahead to preparing and publishing later editions. So how how often will the book be revised? Well, as you all know, we're sort of on a 2 to 4 year schedule, depending on the topic and the rate of change in the field. Now, obviously, and I think Sean will speak more to this, with the advent of e-learning platforms and e-books, an edition might be a phrase that won't make much sense in 10 years or 20 years, and it'll just be continual updates of a constant book. But at least right now, most contracts that we see still are based on that edition model. So I think here is, in the case of revisions, but also in other parts of your contract, most of the boilerplate contract language you're going to see is that it's the publisher's decision when to do a revision, and then the author has to participate. In all these cases, whether it's you're dealing with revision clauses, addition of co-authors, all these things, the more you can try to improve that language so that it's a mutual decision, so that it's done in consultation with the author. I mean, when you are looking at your contracts, read carefully and find any language where it says it's the publisher's sole decision. Because it's really constraining you, and this is your book, this is your name on the cover, and your field. And so, and that's the kind of improvements that, they want to work with you. They want this to be a positive working relationship, but getting those little changes in there so that it's mutual, so that you have a say in how this is going to work, can really go a long way to both making it a better working relationship, but also making sure you're not just at the mercy of this contract and the publisher's decisions. Oh, I'm sorry, I'm not keeping up on my... So let's go on to the midlife contractual changes. So what can be done when an author negotiates contracts with less favorable rates? And this, to be honest, and that's why we're putting so much emphasis on your first negotiation, it's very hard to do once you're past the initial contract. Because the fact is, the publisher knows you're bound by your contract, and they have no obligation to change those terms. Plus, they know you have a vested interest in this book continuing to do well, so you're going to deliver and you're going to do your best for the book. So it's really hard to know, well, how do I get those contract changes? And of course, the key here, like in any negotiation, is clout and leverage. Where is your leverage? Well, this can come from a few places. I need changes or I'm walking away. Well, how famous are you? How much do they need you and your name and your involvement and your being, the one talking about this book to make it a profitable book? So if you are a famous author, if you're the name that's been on there for 10 editions, you have a different kind of leverage. Also, what's the revision schedule? I mean, yes, we all know it's on 2 to 4 years, but how strict or clear is the contract language about those revisions? Because oftentimes the looming production deadline could lead the publisher to be more receptive to contract changes because they want to keep that schedule on track. And they want to make sure the book gets to market when it's supposed to. So if you can say, I really want to get going, but we still need to work out these contract terms. Well, that's then maybe an opening to start improving the contract because they want to keep things moving forward. And the other thing that might give you some leverage is that past mistakes can work in your favor. And what I mean by that, an unfortunate reality, and Julie will talk to this more tomorrow, is that there are often mistakes in royalty statements, and those are getting ever more significant because books are getting so complex. And what even is a book when you have multiple editions and custom editions and 100 ISBNs for one book? So the chances are very high, unfortunately, that error will sneak into these statements and there will be mistakes in your royalty payments. The upside, or the silver lining of that, is that if you're in the midst of an audit or requesting an audit or reporting on problems with your royalty statements, that's a good place then to maybe be able to open the door on some contract renegotiations and to improve the contract terms, both because they want to get you back on track, back in favor with them, but also it might be that some of the contract language is really difficult to translate into a royalty calculation rates. And so there might be a chance to simplify that language and improve that language that will benefit the publisher as well as you. And here's just a caveat on that. If you are doing these kinds of mid-contract negotiations, it likely means you're going to have an amendment to your contract. And then you want to bring just as much care and careful attention to all that terminology as you did to the first contract. Those tend to be shorter, but it's just as important. And another little warning is that it often is the opposite direction, which is that the publisher is proposing changes to your contract. And many of you may have gotten these sort of form letters. We're updating our contracts for all our authors, and it's wonderful, and please sign here. Well, be very careful. As you know, you didn't draft that contract, the publisher did. And look carefully at those changes and just our experience is that more often than not, your older contract is probably better for you than what's being proposed, because a lot of things that are now available and new technologies weren't contemplated when it was written, and so they're not covered by your current contract. So that's really important to carefully review and discuss with expert when you're looking at a contract amendment that the publisher is proposing to you. Okay, let's get to phase 4. Because we're getting to the end of the phase, and I'm getting to the end of my time. So does your contract address the end? And here are the 3 major parts that I want to talk about. So again, we're talking about addition or subtraction of co-authors. But now it's a little different, right? Because now we're not going to work together on a new book. But let's say you're the senior author. It's your book. You need to bring someone in. Now, if you've already found the right colleague and you already know that when you want to bring them in, then it's just a matter of putting some documentation to that and getting started. But if you have to actually go find one, finding the right successor is difficult. It has to be somebody whose approach to the subject matter ties in with yours, but also whose writing style meshes with yours, and whose work style meshes with yours. So it really is sort of like a marriage again. So again, we're back to that prenup. What often works is that, you want to set it up as an audition process. So typically you'll have you'll get 3 to 5 potential authors. They'll do a sample chapter. You want to have them all on the same deadline because you want to see how they work with deadlines. And then you want to, get to review those and get to meet those people. And just keep in mind also, you want to have final say on the selection of this person, or again, in consultation with you, not have this solely subject to the publisher and their approval, because they often are looking at it the lens of, is this person going to drive adoptions? Are they really good at marketing it at conferences? And your concerns as an author are going to likely be very different. Do they work well with me? Are they good writers? Do I have to edit everything they write? So make sure, don't let this be an arranged marriage. Make sure you get a say in who your co-author is going to be. It's often that the junior person is brought in on more of a probationary basis. So they're brought in for one edition, but there's no guarantee of participation in future editions. We have to see how it works out. So you want to have that out as a senior author to make sure it's going to be a good fit. So, and then again, it's the same things we talked about at the beginning about collaboration agreements, division of labor, authority, who is in charge, who has final say. Usually, in this case, it's pretty clear it'll be the senior author. And then very quickly now we're talking about the true phasing out of the senior author. You're getting out. So there might be a couple editions where you kind of move to more of an editor status, and you're supervising the writing, but you're no longer writing. You're still involved. You're still at your basic royalty rate as long as you're participating in this process. But what I'm really talking about now is the step down. This is when you cease working on the book at all. So a lot of contracts will have language that is basically the first edition where an author does not participate, they get 50% of the royalties. So you're not doing anything, but because your name and your work have made this book the success it is, you continue to earn royalties when you don't participate. And then after that edition, it's over. Then no more participation. Well, that's another one of those terms that can be improved. But it's a lot easier to improve it way back at the beginning, because you and the publisher back in your 30s were not thinking so much about phasing out. But again, you can have a second bite at the apple if you're very successful and we want to make this smooth. So for example, often you can improve those terms that you goes over more editions. So maybe you start at 60%. The first edition you don't participate, then goes down to 40, then to 20. It used to be you could actually get publishers to agree to pay 10% ad infinitum as long as this book existed. They now really resist that. They just don't. It's just for an accounting perspective, it's a mess. So it's usually not going to be more than 3, maybe 4 editions where you continue to receive royalties, or your heirs continue to receive royalties. And then quickly on to reversion clauses. This is one of those contract terms you want to think about at the beginning, the out-of-print clause. Well, it was very easy back when we had print books to know what out-of-print meant. They weren't printing books anymore. But what does that even mean now? And so when you look at your contract, you need to look at that language. Because some publishers have improved this, so now it's if sales fall below a certain threshold for 1 or 2 royalty periods, that's going to be considered out of print. And usually they'll make that change for you, but you have to ask for it. Or they might just keep this out of print language, and then if there's one ebook available anywhere, it's in print forever. So now and the thing is, the other thing you want to do is that you want to improve the definition of out of print, but then you also want to make it that if it goes out of print, remember you're still the owner of your book, you're still the copyright owner, that rights will revert to you. And what Zick mentioned, and Sean will get to soon, is the idea that if rights revert, you can take it to a new publisher. You can give this book a new life. And I would also say you want to have that reversion language, but you want to make it automatic. So if the book is out of print, as you've now defined it in your contract, those rights revert to you. You don't have to send a letter requesting that reversion of rights, which can delay you by 6 to 12 months. And then there's something I'm going to skip for now, but I'm going to jump ahead to show you that on our website is an article by Zick all about statutory termination, which is a part of the Copyright Act that 35 years after you've granted someone a right of copyright, you can get it back no matter what your contract says. The statute overrides it. You can notify them and say, I'm demanding all my rights back, because this is often a way to open up a new negotiation with your publisher if they want to hold on to your book. And I'm happy to talk with you afterwards all about that, but I want to give Sean his time, and the article that Zick wrote on this gives you a nice overview of statutory termination. So thank you.
Thanks, Brenda. Well, my part of the program is to kind of play a little bit of a Phil Donahue act here. We have about 10 minutes left, and there's a lot of content. There's a lot of really important information that we've gone through here. But just to kind of test the temperature of the room, how many folks in this room are actually published textbook authors? Just raise your hand. Great. And just with a show of hands, would you say that you're in your early phases or in the mid to later phases? So the folks in the early phases, as Zick and Brenda have defined it, how many of you are in the early phase? Okay, and then how many of you are in the mid to later phase? Okay, it's about half and half. So what would you think would be the most important topic for us to have a little Q&A on? Because we could range all over the place. But let me suggest a couple of things. Oh, Sharon, you have an idea.
How do we register our copyright if we're sending in manuscript that we don't have under contract?
Right, so that's a great question. And I think, Brenda, maybe you could think about answering that one since you mentioned registering copyright. We'll get to that in a second. Is actually renegotiating your contract right now important to you? Are you looking to try to do something to renegotiate your contract? Please raise your hand if that's what you're trying to do at the moment. Okay, okay, raise them high. We need to know. Okay, so maybe that's worth talking a little bit. Is anybody here trying to get your rights back at the present time? Okay, get your publishing rights back at the present time. Okay, one over there. So let me turn the microphone over to Brenda to answer the copyright question.
So just wanted to make sure I heard the end of the question. Is it how to register a copyright in your work, the process of doing that? Okay, yeah, it's quite straightforward. You go to copyright.gov and you look for the e-register. I think that's what it's called now. And it's basically, there's a form you fill out, an electronic form online. You have to select that it's a textual work. And there's also, if you look on the resources page, there's something called circulars, which are some directions for how to do these things. I need to be honest with you, this is a website in dire need of some updating, so the interface is going to be 10 to 15 years old and a little clunky, but it can be done, and there are prompts and explanation as you go through the registration form. It really, you can do it in less than an hour. It's basically giving the title of your work, you give some of your contact information. There is a place where you have to claim what information is yours and what is not. And basically, if you have any work that's public domain or previously registered or belongs to someone else, you just have to say that, but you don't have to specify what that is. So that people often think that's this big hurdle. It's not. You just have to note if it's all original or if parts of it are not. And then if the work has only been distributed electronically, then at the end you can just upload a copy of the work, and that becomes part of your registration record. If the work has been distributed in any kind of physical format, you actually have to mail 2 copies of it into the Copyright Office. And I believe the current registration fee is $55 for a single work, which is really quite reasonable. And you only need to do that once. You register once, and it's registered forever. And later on, your publisher likely will take care of the registration of the book in its final form, but it's still, your copyright record is now prima facie evidence, sorry to throw the Latin in, but that this is yours. And so if there were ever a dispute, the burden of proof would be on the other side to prove that this wasn't yours. So it's a valuable exercise. Yeah.
Once the publisher has the book and the copyright changes, what happens to what you have done?
So when the publisher registers the book, they'll do a new registration, and basically they can disclaim the early work, the pre-existing work that was in your previous registration, so that new registration only covers the new material in the book. Because likely your book will change greatly from the early version that you register versus what your publisher will be registering. Now, the important thing to remember is you are granting your publisher, when you sign your contract, all the rights they need to publish this book. So you've registered it, but you are essentially then giving them a very broad license to your copyright to publish this book. So it's you know, you registered it, it's yours, but then the contract sort of overrides some of that in the sense that you're conveying those rights to your publisher. There was another question behind you? Yeah.
If I register the book on copyright.gov, which I've done before, and the publisher decides the name that I've chosen needs a name, the book needs a name change, can that happen?
Yes. Yeah, so in the registration, you put down the title of the book. That's part of it. So if the published version has a new name, then that's going to be tied to that record, to the publication record. And that brings up something I was really hoping to touch on, which is that if the name of your book is a name of a concept that you've created, if it's your blog, your website, your thing, your theory, you may have trademark rights in that. And so that's something else you work out with the publisher, that you're giving them a license to use the title for that book, but you retain the rights in that trademark. So, Zick, do you want to hop in?
Well, I do. This relates to what I was going to say before about autonomy versus control, something that is part of our lifespan of development in humans as well as in books. Starting when you're about 2 years old, when the child wants to start asserting itself in different ways, and at the same time the parents want to control the child. And it comes again when you're adolescent and you want to establish your own identity. Now you're in the launching stage. This book is your baby. Autonomy, it's something that you've done all yourself. Then you get a publishing contract, which if you read it, you will see that it says exactly the opposite in almost every way, because it says that you assign to the publisher all your copyright, all exclusive rights to publish the book in any way, any medium, any place, to combine it with other things, to slice and dice it, to do anything they want with it, and even to change the name of it. Now think of that. This is your baby, and they want to have the right to name it. Now, that's the way the publishing boilerplate goes. When things go well, of course, the publisher and the author all agree on the title. Everybody is on the same page. When they don't agree, then contractually, it's the publisher's right. I personally, and we as both textbook authors and lawyers, don't think that's appropriate at all. I don't think it's professionally appropriate for you to let somebody else decide the name. The publisher doesn't think it's right for you to have the whole authority. So it has to be done mutually, and it has to be done respectfully, and it has to be done with proper approvals as well as consultation.
Thanks, Zick. That was a discussion really to pick up on one of the questions about, or the point about when you're in the middle of renegotiating with your publisher for whatever reason, if you have that opportunity, keep in mind that there are certain aspects that can be handled mutually, and there are certain aspects where the buck has to stop somewhere, because you can't keep going around forever and ever. The book has to be published. And it's a matter of finding what that right balance is with your publisher, which is why it's so important to build that relationship early on. Editors come and go, but cultures at publishing companies tend to persist. And you need to feel that you understand that culture, because that's really what you're going to be dealing with over the life cycle of your book.
Thank you. I had a question. If you have already signed the contract, but you haven't turned over the bulk of the material yet, can you then copyright what you're doing, or is it too late because you've already signed?
The way in which textbook contracts are done nowadays, they almost all say that you assign to the publisher all of your copyright. I would interpret that as meaning everything you've done in the past related to the book, every previous edition of the book, every future edition of the book. It's different in the trade book world, the world of novels and nonfiction for general audiences, where the general approach is the author retains the copyright. Occasionally, the publisher will let the author retain the copyright, but that's not the way it usually is. And that's not necessarily a battle that you can fight, but the battle that you can fight is, okay, the publisher has the copyright. That doesn't actually mean anything except in connection with a contract that tells you what exclusive rights you are giving to the publisher and what rights the publisher, which holds the copyright, is giving back to you. So the contract can trump the copyright. Who owns the copyright is symbolic at that point.
One thing on that is that when you're I want to follow on that, because when you're negotiating the contract, there's also ways you can hold back certain rights. You know, if there's no chance that this book is going to be translated, for example, then why grant that right to the publisher if they don't really want it? So go through and think about what is likely to be the ways this book is used or developed or exploited, and then say, well, if we're not going to actually be doing that, can we just strike those from the contract? Or sometimes what we've done is you give the publisher, say, 2 or 3 years to exploit that right. And if they haven't, it reverts to you. So you want them to do it, you want them to develop the book, but you want a chance that if they're going to let that sit idly, that you get it back and can develop those parts of it.
Okay, everybody, we have just, unfortunately, time for one more question. It is 10:13, so we literally have 2 minutes. So I'll turn the microphone over to Ken.
With the increasing trend towards digital publication in my publisher, there's been talk of revising continually rather than episodically, which could mean an end of editions per se, which would have implications for contracts where the royalty rate has an escalator that kicks in with each edition. Do you see that trend going anywhere, and what implications do you see in that?
It's a great question, and Sean may have insights on this too. I mean, sadly, I think it's one of the places where the contracts haven't really caught up, and especially the older contracts really don't reflect this situation. So I think the more you can, if you reopen negotiations, or if you're facing that kind of a book, then instead of tying things to the sales of units that lead to escalations on a certain edition, it may be tied to overall proceeds, from the book in any of its, the ways it's distributed, that if sales rise above a certain sales level, then your escalations kick in. And as far as the book that's a never-ending revision, I mean, they're not going to keep escalating until it's at 100%. But, once you hit the top of your escalation range, that's the best place you want to be. But I don't think they've really captured yet. The contracts have not really captured that change. So I think it's kind of a work in progress, because the publishing industry has changed so rapidly in the last 10 years that the contracts just haven't quite caught up to reflect this.
Yeah, I'd say in addition to the contracts, the royalty departments haven't caught up, which is why I think Julie and Rich get so much business these days, and Hankura. So it is 10:15. More questions, absolutely. You can catch Zick and Brenda on breaks or in other sessions. You'll be here. Are you here tomorrow as well? Yeah. Okay. So thanks very much.